Hello, my name is Brian Mayer. I'm an attorney practicing in Southern California, and today I'm going to be answering the important question of how do we get rid of a bad judge on our case. Now, if you find the information I have here to be useful, I would really encourage you to consider subscribing to my channel, liking the video, and leaving any comments, because those things let me know that these things are of value, that I can create more videos of similar topics that hopefully will be helpful not only to you, but to the justice system in general and other people who are going through the same things. And it's just an easy way to make sure that the information gets out there and that I know that these videos need to be continued to be put out. Now, before I start, the first thing that I want to say is that ideally you would be watching this video before you ever set foot in court. I'm guessing for most of you, the fact that you're watching this means that you already have a problem with a judge, and these things are just so much easier to deal with the sooner on in the process that you approach it. So if you know anyone who is about to go into litigation, who's about to go into court, who's thinking about filing a lawsuit, sometimes the judge that you have on your case makes all the difference in the world in terms of what the outcome is. So I really encourage you to tell that person about this video and share this video with that person so that they can be informed going in, okay? And so I'm going to talk about first what the options are in terms of removing a judge that's been assigned to a case. Then I'm going to talk about what you ideally would be able to do in terms of selecting a better judge in this process, or helping to bring about getting a better judge assigned to this process. I want fairness, and I want an intelligent decision for all of you in all of your cases to be made. And that's what hopefully this will, to an extent, help you do. So there are three ways that a judge can be removed from a case, okay? So the first way is by far the easiest when it can be exercised, and that's through what's called a peremptory challenge. That's not a preemptory challenge, it is a peremptory challenge. P-E-R. And the way a peremptory challenge works is basically it is the right to have a judge, one judge, removed from your case without any specific explanation why. Now, California allows for this, other states allow for it. New York, for example, allows for it. Most states allow for it, and I can't go through the list of 50 states which ones do and don't, but it's something that you can figure out through Google or talk to an attorney in your area if you need to. But the peremptory challenge allows you to remove a judge for any reason, or basically no reason at all. You merely have to state, I don't think that this person can be fair in my case. And you can do this once, again, no explanation needed. The challenge, the difficulty with a peremptory challenge is that it has to be exercised before the judge hears anything on your case. And this sort of removal without cause for a peremptory challenge ceases to be an option as soon as the judge makes any sort of temporary ruling in the case. Now, obviously, what's difficult about that is that for most people, they don't realize that their judge is no good at what they do until after they've already started to hear their case. So I'll talk about what to do again at the end of the video, but for those of you who are still in a position where maybe the judge has not made any sort of ruling in your case, a peremptory challenge is an option. The case, if a judge is peremptorily challenged, then they will be removed from the case, and the case will be assigned to an entirely new judicial officer. Secondly, the second way to remove a judge from the case is actually through what's called a presumed bias. Okay, it is there are certain cases where a judge must be removed from the case based on certain connections that they have to the case. Now, again, these specifics tend to vary a little bit, but just in general, I can tell you, for example, that if the judge has any sort of financial connection to the case, if they have certain familial connections to the case, then the judge must disqualify themselves and they cannot be heard. And if the judge proceeds on the case with those sorts of conflicts conflicts if the judge proceeds with those conflicts in effect, then it can actually result in a reversal on appeal, or the case being dismissed, overturned on appeal. So this would be the sort of situation, for example, if a judge had, just to name a few of the types of biases that can come up, if a judge had actually consulted, when the judge was in private practice, if the judge had lended their expertise or consulted with one of the parties on the case as it relates to the case, if the judge is a close family member of one of the individuals on the case, if the judge if it involves, for example, a company, some sort of business, and the judge has a financial stake in that business. It can arise even if an attorney on the case, or in some cases it can even arise if there's an attorney on the case, or if or the client on the case who contributed to the judge's election campaign. And so where I think most people make a mistake about this, though, is that there really does have to be certain close connections in order for this to take into effect. And I'm outside of Los Angeles metropolitan area, and there are 12 million people in the city. Nobody knows anybody. But if you move into a smaller community, it's not uncommon that you have a situation where a judge kind of knows half the town, and maybe the judge knows the party's cousin who built a fence for them, or they go to church with this person, or they live down the street from this person, they attended the same 4th of July fireworks display with the person. Those things are not intended to be disqualifying. It really comes down to whether or not there's a tangible interest in the judge's position, or their personal or professional position in this other person. Merely knowing the person, being friends with the person, that sort of thing, those are not automatic disqualifiers. There are things that will automatically disqualify the judge, but those are not automatic disqualifiers. Every case kind of has to be looked at in its individual capacity, and you have to say, okay, is there that firm, tangible bias that takes place? Is it this person's mother? Those sorts of things. Depending on how close the connection is, will affect whether or not you have that bias in your case, but that can be an automatic disqualifier. My recommendation is, if you have questions about whether or not this relationship is disqualifying, you can take a look at the statute in your state, or you can speak with an attorney to see if it's disqualifying, but it's something to look out for one way or another. So think to yourself, is there a connection there? If so, is it the sort of connection where there's a financial interest or some sort of close familial connection to the party or the attorney? And if the answer is no, then it's probably not an automatic disqualifier. But if the answer is yes, it probably is, and you could get the judge removed and sent over to a new judge. Now, the third way is through a demonstration of an actual bias, and it doesn't have to be through some sort of close connection like we talked about there. And this could be a bias for anything. As long as the judge is not coming into it with basically a blank slate. If one party, if it's a race from the start to the finish line, if one party has one step ahead of the other at the starting mark, then that's the sort of bias that can lead to removal of the judge from the bench. And this would be the sort of situation where, let's say you have a judge who has demonstrated in the course of conduct that, let's say you have a client who is, let's say you have a client, a party who's Somali, and the judge cracks a joke about the conditions of people coming over from Somalia, and there is some sort of clear demonstration of, or even implied demonstration of bias from the judge there. That can certainly be disqualifying. If the judge is up there on the bench and they're best friends with one of the parties, and there's no familial connection, no financial connection, but they have plans to go out fishing that weekend, and the judge says, yeah, well, we'll have to not talk about the case on the fishing trip, wink, wink. That can absolutely certainly be disqualifying, but it all really depends on the situation. But if the judge, even if there's no automatic presumed bias there, if there can be a demonstration of actual bias, then that can be a basis for removing the judge. Now, something about that to know is that you can't have a judge removed from the case, from any specific case, simply because they are bad at being a judge. Okay, if they're up there and they're making terrible decisions, and they're terrible decisions without some sort of demonstrated bias, that's not a basis for removing a judge. It can be a basis for appeal, but it's not a basis for removing the judge. So simply being bad at your job is not a basis for removing a judge. You need that to be able to demonstrate that sort of bias. Now, unfortunately, this is actually the most common scenario that comes up with people, and it can also be one of the hardest to prove, and also one of the most, not only one of the hardest to prove, but also one of the most difficult procedurally, because you basically have to file a motion, or in some cases what's called a writ sometimes what's called a writ, W-R-I-T, and you basically have to go to the court and say this person needs to be removed. Oftentimes, especially in smaller communities, the case will be kicked over to another county or another judicial district because the judges within the district don't want to be accused of bias in the decision of whether or not to remove their colleague from a case. I've seen that happen before, and sometimes it's difficult to decide whether to do these things because on the one hand, for the judge who you're asking to be removed from the case, you don't want to tick them off any further. But what I usually tell clients is, look, it's already so bad that you want this person removed. How much worse is it going to get? And at least if you file, you give them sort of the heads up that they're being watched and they're going to be scrutinized. So you need to stop pay attention to, maybe look at what you're doing and check yourself to see if you're being unfair in this case. So that's basically the third option. So the three options are: number one, a peremptory challenge; number two, removal for cause; removal based on presumed bias, removal for cause; and number three, removal for specific bias as it applies to your specific case. Now, I said earlier in the video that ideally you would share this video with someone who is about to go into the case, because really the best option, the easiest option, the quickest option, the all-around 100% ideal option is if you can eliminate a judge before they ever hear your case through a peremptory challenge. So the thing to do, and it's difficult to find the time to do this oftentimes, the thing to do is before you go into a case, before the judge has a chance to rule on anything, you research the judge on the case. Just see what their record is, see what their reputation is, see what their background is. If you can, talk to attorneys in the community and see what they think of the case. You can go online and research. And also, and this is really important, go back and take a look to see if what this judge's history is in terms of what they did before they sat on the bench. Oftentimes, the judge will take the bench having never ever heard your type of case before they go on the bench. I can't tell you how many times judges come out of a prosecutor's office, for example, and have been practicing criminal law for 20 or 30 years, and they sit down and they are hearing a family law case, having never in their life touched a family law case, having never represented a party in family law case, having never even had their own family law case. And now they're supposed to, with about 15 minutes per case, decide what's happening in people's personal lives and their children's lives, just based on their area of practice dealing with an entirely separate type of law. So you really want to take a look, if you can, beforehand to try to make that determination. And so I really encourage you to share this video with anyone that you know who might be about to go into litigation or is thinking about going into court to handle these sorts of things. Those are the options that are available. Sometimes you just have an incompetent judge who's on the case. I wish that there was a solution in every case, but these are the solutions that the law allows. And what I would say is basically just remember that if the decision is bad enough, even if you can't prove bias, even if you can't remove the judge, appeal is always an option. It is good if you can afford it to have an attorney to help make sure that you've preserved every possible path for appeal if you know that you're dealing with a difficult judge, but a lot of people can't do that. So just make sure that every decision by the court is being explained. You can ask the court to explain its decision so that can be protected on appeal, and the court can look at the judge's specific reason for making their decision. In California, where I practice, this is called asking the court for a statement of decision, which is basically the explanation for the rationale behind how the court reached this conclusion, and that sort of boxes them in for appeal so that the appellate court can decide definitively whether or not that specific rationale applies. So thank you very much for watching the video. Again, if you found this was informative, please subscribe to my channel. Please like the video. Feel free to leave comments below and share it with anyone who you think might benefit from it. Thank you and goodbye.